Well, folks, this is the three-part Exhibit A filing filed yesterday by Kathleen Zoner. First one's 198 pages, 98 pages. Second one's 145, and the last one's 149. I don't want to read through all this, but I'm going to just skim over it most. But here we go. Second amended motion, the third motion, post-conviction relief pursuant to Wisconsin Statute 97406-80515. Second amendment motion, the third motion, post-conviction relief. Please take notice that the petitioner, Stephen Avery, by and through his current post-conviction attorneys, Kathleen Zoner, Associates, and Stephen Richards, respectfully moves this court, pursuant to Wisconsin Statute 97406, for order vacating the judgment of his convictions and sentence and ordering a new trial. In the alternative, he asks that the court grant a new trial in interest of justice pursuant to Wisconsin Statute 80515, or its inherent authority because the real controversy was not fully tried. In support of the second amended motion, Mr. Avery states as follows. Mr. Avery requests evidentiary hearing and that he produce that hearing. Introduction. Two new witnesses have emerged in Mr. Avery's case with new and compelling evidence about a murder mystery that intrigued a worldwide audience. The rush of judgment and television that led to the arrest, prosecution, and conviction of Mr. Avery is exposed by these new witnesses to provide new and undisputed evidence that directly links Bobby Dassey to the murder of Teresa Halbach and the framing of Mr. Avery. Furthermore, this is new evidence allows the reconsideration of the real motive of the crime as being a sexual homicide, which was cumulative the obsession by Bobby with viewing thousands of images of violent, deviant pornography on October 31st, 2005. The obsession fantasies of Bobby became a horrible reality when Teresa Halbach was brutally assaulted and murdered by two rifle shots to her skull. Her body was mutilated, as were many of the female subjects in Dassey computer images. Bobby was in possession of a Halbach vehicle, which contained crucial evidence of the terrible crime. Ms. Halbach, blood key, electronic devices, license plate, which was concealed in another salvage car, and Mr. Avery's carefully deposited blood on the seats and dash and DNA on the hood latch of being in possession of the vehicle. Bobby was able to control the direction of the investigation. He planted the vehicle on the Avery property. After he deposited Mr. Avery's blood and DNA in it, he and Ms. Halbach's key and electronic devices ended up in Mr. Avery's bedroom and burn barrel. Bobby did all this to exculpate himself and to frame his uncle, Mr. Avery. Mr. Avery does not have to prove who committed the terrible crime to receive relief. This is not the intent of the purpose. However, he does have a right to prove he did not receive a fair trial. The new evidence which established that Bobby meets all the Denny criteria to a third-party suspect, and the evidence of two Brady violations demonstrate that Mr. Avery was deprived of constitutionally guaranteed right to present a complete defense to charges against him. The case began in early November 2005 with the disappearance of Teresa Halbach, a 25-year-old professional photographer. Ms. Halbach was reported missing on November 3, 2005. Volunteer researchers found Ms. Halbach's Toyota RAV4 on the 40-acre site of Avery's salvage yard. A salvage yard business where Mr. Avery and other family members lived and worked on November 5, 2005. Ms. Halbach had photographed vehicles this site previously. Mr. Avery request, recording the state witness Bobby. Ms. Halbach was last seen walking towards Mr. Avery's trailer on October 31st, 2005. After finding Ms. Halbach's RAV4, law enforcement searched the Avery property and over the course of the next 4 months discovered and identified evidence including burned bone fragments in and around a burn pit, with DNA matching Mr. Avery's and Ms. Halbach's blood in the RAV4, remnants of electronic devices and a camera, the same model as Ms. Halbach's in a burn barrel, Ms. Halbach's RAV4 key in Mr. Avery's bedroom. With Mr. Avery's DNA on it, and Mr. Avery's DNA on the blood on the hood latch, Therefore, the positive state later claimed by Mr. Avery's sweaty hands, and a bullet in Mr. Avery's garage containing Ms. Halbach's DNA. Third-party suspects. On July 10, 2006, before Mr. Avery's trial, the trial court entered an order, an entitled order regarding state motion prohibiting evidence of third-party liability, Denny motion. The order specified that the defendant intended to suggest that a third party, other than Brendan Dassey, is responsible for any of the crimes charged. The defendant must notify the court in the state of such intention at least 30 days prior to the date of the trial. The trial court further ordered that the defendant would be subject to standards relating to the admissibility of the third party liability evidence pursuant to State versus Denny. In the light of the court's order, on January 10, 2007, Mr. Avery filed a defendant's statement of third-party responsibility. There, Mr. Avery stated that he did not kill Ms. Halbach and that there was at least a reasonable possibility that one or more unknown others present at or near the Avery salvage yard on the afternoon of October 31st killed her. Mr. Avery identified several persons as potential alternative perpetrators: Scott Tadich, Andre Martinez, Robert Fabian, Charles and Earl Avery, and the Dassey brothers. Mr. Avery argued that Denny did not apply to circumstances in his case, and that as a result he should not be bound by the third part test set forth in Denny. He further argued that even if Denny did apply to his case, he should be permitted to introduce evidence as a trial of several alternative perpetrators in this case. On January 30, 2007, the trial court entered a decision order on the admissibility of third-party liability evidence. The court held that Denny's legitimate tendency test applies to every evidence defendant wished to present regarding potential third parties who might have been responsible for Ms. Halbach's murder. The trial court found that in the absence of the motive, it certainly may have been more difficult for the defendant to offer evidence which is relevant to the material connecting the third person to the crime. The court simply finds nothing in an offer made by the defendant that goes beyond the level of speculation. Verdict. On March 18, 2007, Mr. Avery was convicted following a jury trial of the first-degree intentional homicide and a felon possession of a firearm. The jury found Mr. Avery not guilty of mutilation of a corpse. On the 29th of 2009, prior post-conviction counsel filed a motion for post-conviction relief on Mr. Avery's behalf, pursuant to 809-30, seeking a new trial on grounds that the trial court improperly excused deliberating juror, the trial court improperly excluded evidence of third-party liability. On the 25th, 2010, motion for post-conviction relief was denied by Honorable Patrick L. Willis in order. Regarding the issue of Bobby's third-party liability, Judge Willis found that the only evidence offered by the defendant to show a motive on the part of Bobby Dassey consisted of evidence allegedly supporting a motive to frame Stephen Avery. No evidence is offered to suggest Bobby Dassey had motive to murder Teresa Halbach. Judge Willis concluded. The evidence offered against Bobby Dassey probably did meet the opportunity and direct connection to the crime requirements of the legitimate tendency test because of the presence of the property at the time that Teresa Halbach was there. However, without any showing of motive, the third-party evidence against Bobby Dassey is precluded under Denny. On December 14, 2011, the Supreme Court denied Mr. Avery's position review. On February 14, 2013, Mr. Avery filed his first and only pro se Colorado post-conviction motion. The motion was denied by Honorable Judge Angela Sikowitz on November 23, 2015. On October 11, 2019, current post-conviction counsel appealed the circuit court's denial of Mr. Avery's second post-conviction motion, and all the supplements he filed motions to stay remand concerning the two additional claims. At the appellate court direction, Mr. Avery raised claims and motions to circuit court or supplemental post-conviction motions. The circuit court denied motions to supplement. On April 12, 2021, Mr. Avery filed a motion to stay and remand. The appellate court denied it. The appellate court July 28, 2021 decision. On July 28, 2021, the appellate court issued per curiam opinion upholding the circuit court's summary denial of Mr. Avery's claims raised in his 97406 post-conviction motion, and two supplemental motions holding. Avery's 97406 motions are insufficient on their face to entitle him of hearing. Petition for review, November 17, 2021. Response to the Supreme Court denied Mr. Avery's petition for review. The appellate court reserved Mr. Avery's ability to file successive motion current claims. On April 12, 2021, during the pendency of Mr. Avery's appeal, Mr. Avery filed a motion for the appellate court to stay his appeal and ran for evaluation of a new claim. The appellate court acknowledged this claim, stating the following. On November 9th, 2020, we notified the parties that the case had been submitted to the court for decision on briefs. On April 12, 2021, Avery filed another motion with this court to stay his appeal and remand for evaluation in the claim. The claim concerns an alleged Brady violation, factual basis for which Mr. Avery obtained on April 11th, 2021. Specifically, the claim is based on the affidavit of Thomas Lewinsky, a Manitowoc motor route driver who attests that days after Ms. Hallbach's death, while on the paper route in the early morning hours, he spotted a shirtless Bobby Dassey and an unidentified older man pushing Ms. Hallbach's vehicle down Avery Road towards the junkyard. Mr. Lewinsky further attested that he delivered the paper. Bobby Dassey attempted to block this exit, causing him to swerve and drive into a shallow ditch. Mr. Lewinsky claimed he had called the Manitowoc Sheriff's Office later that day to report that he had seen, but was told that they already know who did it. He also claims to have attempted to contact Avery's trial attorneys after season 1 of Making a Murder, but never heard back from them. Further, in July 28, 2021, opinion, the appellate court advised, when Avery filed his motion, he had already twice stayed his appeal, each time because he asserted that new claims related to these previously litigated and that it would be most expeditious to resolve them as part of the instant appeal. By the time Avery filed the new motion, however, we had already evaluated the legal and factual basis for the claims already raised. Therefore, we are in a position to conclude that the newly raised Brady claims bears little or no relation to those claims already before us. This is instead a distinct issue that the Circuit Court should resolve on a standalone basis through Wisconsin Statute 97406. Avery's later motion arrived while our decision in his appeal was forthcoming. It would be an effective use of court resources to now and once again delay his appeals. The appeal court reserved Mr. Avery's ability to file a successful 97406 motion and claim most recent filing concerning the new witnesses who came forth on. That's the thing I don't understand. The Court of Appeals basically gave Zellner a blueprint on what to do, going back to the Circuit Court. And then the district attorney, or Attorney General for Wisconsin, intervenes and asks him to deny his motion for an evidentiary hearing. Like, what the fuck is really going on? But anyways, specifically, the appellate court instructions the following. As discussed below, we are not addressing Mr. Avery's most recent filing to this court or discussion of Motion 6, which seeks to directly connect Dassey to the Hallbach's murder. If Avery wishes to raise a claim, he will need to bring new Wisconsin Statute 97406 motion. The motion would need to survive the most excellent narrow scrutiny and be found to have merit, in which the case evidence presented might supply the missing direct connection. In event, the VLC evidence might become relevant to showing Dassey's motive and might bear whether Dassey is or should have been a viable Denny suspect. We express no opinion on the merit of any such 97406 motion, as all such issues would be for the Circuit Court to decide in the first instance. Regarding certain claims Mr. Avery raised in his motion to reconsider the Circuit Court's October 3rd, 2017 order denying his second post-conviction motion, and two supplements, the appellate court found that neither we nor the Circuit Court have squarely considered whether these claims are procedurally barred under Escalia Narnando, and whether Avery pledged sufficient materials entitling him to a hearing. Such consideration would have come to a separately filed Wisconsin 97406 motion, and we express no opinion as to whether such claims would be barred in the event such motion is filed. Thus, new material that Mr. Avery raised in his motion reconsidered and supplement Avery never ruled upon the circuit court. Evidence supporting Mr. Avery's third 97406 post-conviction motion. Newly discovered evidence. New witness provided direct connection between Bobby and the Hallbach murder and planting evidence to frame Mr. Avery. Mr. Avery's new witness, Mr. Thomas Sawinski, contacted Mr. Avery's current post-conviction counsel in December of 2020. Mr. Avery had already filed his appeal on October 11th of 2019. Mr. Sawinski stated that he had witnessed Bobby and one other individual, a bearded man, pushing Ms. Hallbach's RAV4 onto the Avery salvage yard early mornings of November 5th. Mr. Sawinski claimed that he had reported this information to the Manitowoc Sheriff's Office. On April 11, 2021, Mr. Sawinski provided an affidavit to Mr. Avery's current post-conviction counsel stating the following. Mr. Sawinski was a motor route driver for Amended Newspaper Incorporated and delivered papers to Avery Savage in the early morning hours of November 5, 2005. Prior to delivering the newspapers to Avery salvage yard, he turned onto Avery property and witnessed two individuals, a shirtless Bobby Dassey and an unidentified older male, suspiciously pushing a dark blue RAV4 down Avery Road towards the junkyard. The RAV4 did not have its lights on. Mr. Sawinski drove past the two men and delivered newspapers to the Avery mailbox, and then he turned around and drove back towards the exit. When he reached the RAV4, still over there, Bobby Dassey attempted to step in front of his car to block him from leaving the property. Mr. Sawinski came within 5 feet of Bobby Dassey, and his headlights were on Bobby during his entire time. Then Sawinski swerved into a shallow ditch to escape Bobby and exit the property. Mr. Sawinski states in the affidavit that he called out Paperboy, gotta go, because he was afraid for his safety. He further said that Bobby Dassey looked him in the eye and did not appear to be happy to see Mr. Sawinski there. After Mr. Sawinski learned that Teresa Hallbach's car was found later in the day on November 5th, 2005, he realized the significance of what he observed and immediately contacted the Manitowoc Sheriff's Office. Exhibit 1, Mr. Avery's motion to remand state appeals. Mr. Sawinski's original affidavit, following date April 12, 2021, Mr. Avery filed a motion for remand to state appeal to the appellate court containing Mr. Sawinski's original affidavit. The Sawinski evidence provided Mr. Sawinski to Mr. Avery's current post-conviction counsel is newly discovered evidence which provides the missing connection between Bobby and Ms. Hallbach's murder, making him a Denny suspect. Discovery of new evidence may constitute a sufficient reason for second or subsequent post-conviction proceeding under Wisconsin Statute 97406. To prevail, however, the movement must carry that burden of providing the evidence is issue newly discovered in most cases to obtain relief based on newly discovered evidence, and convicted person must establish by clear and convincing evidence that evidence was discovered after conviction and the defendant was not negligent in seeking evidence. Well, we don't have it. What they did. So what else are they hiding in their safe? Sawinski evidence was discovered after Mr. Avery's conviction. Mr. Avery did not have the Sawinski evidence before Mr. Sawinski came forward to Mr. Avery's current post-conviction counsel in April of 2021. Mr. Sawinski attempted to contact the Innocence Project and Mr. Avery trial defense counsel via email in 2016 regarding the evidence he had to no avail and had no previously provided to Mr. Avery's counsel. Rather, Sawinski evidence was reported to the Manitowoc Sheriff's Officer by Mr. Sawinski, but the evidence was suppressed from Mr. Avery by prosecution. We already know that Manitowoc doesn't file reports because on November 3rd, when Andrew Colborn talks to Stephen Avery, there's no mention of it at all. Somehow somebody tells Mark Wiegert that Teresa Hallbach and Stephen Avery are friends. It's obvious they contacted everybody by phone first. We got Zipperer refusing to talk to them and tells them and talk to my lawyer. That's why Dietering is sent over there. But then we got the other individuals. The first stop, he actually calls the sheriff's department looking for Mark Wiegert. Neither Mr. Avery nor his counsel were noticing Mr. He acknowledged Bobby's actions on November 5th, finding that Williams had not failed to use diligence in pursuant to the jury misconduct claim. The record contains evidence which had put a reasonable attorney on notice, said it's not response to the deletable omission of material information. The evidence and material is an issue to Mr. Avery's case. The Swinski evidence and material to several issues in Mr. Avery's case. Most importantly, it is material for establishing Mr. Avery's defense. I'm going to stop here. Even them having Swinski's phone call wouldn't have produced anything because he didn't say anything in the recorded phone call. He was transferred to a detective, and he didn't do his job. Or he did, and he was told not to. Most importantly, material establishing Mr. Avery's defense that a third party committed a crime against Mr. Halbach, and it's material for establishing a direct link to Bobby and his third party Denny suspect of opening the door, reconsidering the VCD, as establishing a sexual motive of murder. Additionally, Swinski evidence and material evidence for RAV4 being planted by Bobby, including Mr. Avery's blood and DNA. The RAV4 also contained the Halbach's vehicle key, Ms. Halbach's electronic devices, which were discovered in Mr. Avery's bedroom and burn barrels, respectively. Further, Swinski evidence is material that impeached Bobby's trial testimony that Ms. Halbach never left the Avery property and that she had last seen walking toward Mr. Avery's trailer. Bobby was the state's primary witness against Mr. Avery during the opening statement. Prosecutor Kratz explicitly informed the jury of the significance of Bobby's fugitive observation on the date of Ms. Halbach's disappearance. You are not going to hear that Bobby Dassey was the last person, the last citizen that was seen Teresa Halbach alive. Bobby's testimony was the most determinative of Mr. Avery's guilt because the state used it to establish that Halbach never left the Avery property. At a trial, Bobby testified that he observed Ms. Halbach's light green or teal-colored SUV, blue, pink, purple, whatever you want to call it, 97, 94, 98, 99, because they write different dates on different multiple documents. Pulled up driveway 2:30 p.m. Bobby then observed Miss Halbach exit the vehicle, start taking pictures of his mom's maroon van right in front of the trailer. Bobby testified he observed Miss Halbach walking towards the door of Miss Avery's trailer. Now he claims he only watched her for a very short period of time, but he can describe exactly what she was wearing. And Stephen Avery physically talked to this woman and couldn't remember what she was wearing. So why is Bobby Daffy has such detail on that? Just a question. Following exchange occurred with Prosecutor Kratz and Bobby. After seeing this woman walking towards your Uncle Stephen, did you ever see this woman again? No. When a defendant seeks to present evidence and a third party committed the crime for which the defendant is being tried, the defendant must show a legitimate tendency that the third party committed this crime. In other words, the third party had motive, opportunity, and direct connection to the crime. The support of the production of the third party perpetrator evidence that must be legitimate tendency that the third person could have committed the crime. The defendant need to establish the guilt of the third party to the level that would be necessary to abstain. Bobby was one of two only witnesses whose testimony the jury requested review during the deliberations. The conviction, however, which evidence simply affords possible grounds of suspicion against another person, should not be admissible. Legitimate tendency that tests to ask whether provided evidence is so remote in time, place, and circumstances, a direct connection and cannot be made between the third person and the crime. The Denny requirements are now satisfied. Bobby's motive to commit the murder of Teresa Halbach. Under the motive prong, the court must question whether the alleged third-party perpetrator had plausible reasons to commit the crime. The defendant's motive to commit the homicide is widely considered to be relevant. The admissibility of the evidence of the third party's motive to commit the crime charged against the defendant is similar to what would be in the third party were on trial himself. Other have evidence Other acts of evidence may be admitted when offered to other purposes, such as proof of motive, opportunity, intent, preparation, plan, knowledge, identity, and absence of mistakes or accident. Law enforcement considered pornography and evidence of the motive in Miss Hallbach's murder. The clear working theory of investigators was that the murder of Miss Hallbach was motivated by sexual assault. Pursuant to that theory, the Degassi computer was seized by law enforcement on April 1st, 2006. Evidence of Bobby's motive to commit Miss Hallbach's murder is contained on the hard drive of the Degassi computer, namely the material contained in the Veely CD. The appellate court acknowledged that the evidence could be relevant to establishing the motive element and denied the test if the new evidence directly connecting Bobby was raised. Specifically, the appellate court stated the evidence, Lewinsky evidence presented, might supply the missing direct connection. In an event, the VCD evidence might become relevant to showing Dassey motive, and it might bear whether Dassey is or should have been viable to any suspect. Detective Veely's forensic examination of the Dassey computer searched for the specific words user had searched. Detective Veely selected the specific words and conducted the search of those words. There are 2,632 search results in the following words for blood, body, bondage, bullet, cement, DNA, fire, gas, gun, handcuff, journal, MySpace, news, RAV, stab, throat, tires. These selected words establish a direct link between the specific evidentiary items related to the Hallbach murder and the searches performed on the Dassey computer. The Veely CD contains the state's recovered pornographic images relevant to material to the Hallbach murder. The Veely CD refined that 14,099 images on the 7 DVDs that trial defense counsel received in discovery recovered 1,625 violent pornographic images, which have been deleted. The recovered porn depicted violent images of the torture and mutilation of young females. The search warrant is attached to the administrator's motion because it is not otherwise found in the circuit court record. Brad Dassey, Barb's stepson and half-brother of Brian, Bobby, Blaine, and Brendan, avers that he had a conversation with Barb in which she indicated that she had hired someone to remove evidence from the Dassey computer. I don't think she used those words, but the authorities interviewed Brad after he reported his case on June 6, 2006. Special Agent Fassbender and Investigator Uyghur interviewed Brad, who provided information about the Dassey computer deletions. Thomas Fassbender, DCI Report 105-177-284, attached and incorporated here as Group Exhibit A1. The new forensic examination of the Dassey computer corroborates the affidavit of Brad. Mr. Hunt, in the computer examination, detected 8 periods in 2005 close to the date of the murder for which files are missing and presumably deleted from the Dassey computer. August 23 through 26, August 28th through September 11th, September 14th through the 15th, September 24th to October 22nd, and October 23rd, 24th, October 26th through November 2nd, November 4th through the 13th. Now, that is a problem because the computer was in Bobby Dassey's bedroom, and the property was shut down from November 5th until the 12th. So that means between the 4th and the 13th, there's only 2 days it could have occurred. Oh, great. In reviewing images contained on the Veely disc, Special Agent Thomas Fassbender made the following observations. Photographs of both Teresa Hallbach and Stephen Avery with an apparent date of April 18, 2006. There were numerous images of nudity, both male and female, to include pornography. Pornography included both heterosexual, homosexual, bestiality. There were images depicting bondage, as well as possible torture and pain. There are also text images with the name Emily. There were images depicting potential young females, including the infant defecating. There are images of injuries to humans, to include decapitated head, badly injured, bloody body or bloody head injury, and mutilated body. This disc received from Detective Veely, as well as the hard copy pages of the instant message conversations, were maintained in Special Agent Fassbender's possession. Attached to Incorporated Exhibit A2. Is it any better? Or is it still shit? There's sufficient evidence that only Bobby, who had access to the Dassey computer during the day on weekdays between approximately 7 a.m. and 3:30 p.m. Barb's work schedule was from 6 to 4:30 every day, Monday through Thursday, or every week. Brendan and Blaine would get picked up from the school bus on every road between 7:08 and 7:13 and dropped off at the same place between 3:30 and 4. Therefore, Barb, Blaine, and Brandon, the three other individuals living at the Dassey residence, are excluded from having access to the Dassey computer at the time most of the violent searches occurred. Moreover, on 28 searches from the most violent porn images primarily occurred on the weekdays when only Bobby was in the Dassey residence. It is undisputed that Mr. Avery never accessed the Dassey computer. He did not have the password for the Dassey computer, nor did he have possessed a key to the Dassey residence, which he was locked when no one was home. The only time Mr. Avery ever entered the Dassey residence was when one of the Dassey family members was home. Mr. Avery worked at the Avery Salvage Yard during the weekdays from 8 to 5. Moreover, Mr. Avery was eliminated from all 15 of the 128 searches for the most violent porn images issued simply by having been arrested on November 9th. Brennan would have been eliminated from all the 26 of the 128, 20.3% searches for the most violent porn images issued simply have been arrested from March 1st. So, this is attesting that the searches continued after both of them were arrested. Bobby testified on October 31st, 2005. He was the only person home between 6:30 a.m. when he claims he left to go hunting at 2:45. Therefore, it is undisputed that Bobby was the only person home on October 31st when searches were made of the Dassey computer between 7 a.m. and 9:33 a.m., 10:09, 108, 151, prior to Ms. Hallbach's arrival on the Avery Salvage Yard. The timing of these internet searches on October 31st directly contradicts Bobby's trial testimony that on the day he was asleep from 6:30 a.m. to 2:30. On November 17, 2017, an interview of Bobby by state investigators, Bobby claimed that the Dassey computer was located on a desk in the living room at the time. When Bobby was asked if the Dassey computer was ever located in his bedroom, he stated it was not. Well, we have video evidence from Tyson that the computer was where we say it is, in the bedroom. As Bobby's statement is directly contradicted by the crime scene footage by Sergeant Tyson on November 12th, which shows the Dassey computer was located in Bobby's bedroom. Bobby's statements are further contradicted by his brother, Blaine, who stated in his affidavit to current post-conviction counsel on June 25, 2018, that the Dassey computer was located in Bobby's room and Bobby was primary user of it. Wisconsin Statute 904 provides evidence of other crimes, offer proven motive, opportunity, intent, preparation, planning, knowledge, identity, absence of mistake, accident, admissible. 45. The depicted acts of violent pornography Bobby was viewing are sufficiently similar to the violent murder of Ms. Hallbach. The evidence of Bobby's searches for violent pornography images is not so remote in the time of the inadmissible, but rather so close in time to Ms. Hallbach's murder that the searches are direct evidence of Bobby's motive to kill Ms. Hallbach. In 1,625 previously deleted but recovered images of violent pornography could establish motive for the trial defense. Where the defendant's possession of pornography videotapes, pictures, blah, blah. The defendant and dresser argued that the videotapes and pictures were irrelevant and constituted inadmissible prosecuting evidence. Tom Sugar disagreed, stating that the fact that the defendant maintained a collection of videos and pictures depicting intentional violence is probative. The state claimed that they had obsession with the subject. The district court held that although evidence of the general character of a defendant is inadmissible to prove he acted in conformity therewith and the above expectation from. Sorry. Dressler is pursuing authority that the same result should occur here. Ms. Halbach was killed in a violent manner, maintaining the violent porn images and probative to establish that Bobby had an obsession with the violence and therefore was more likely to commit murder. The violent porn images are relevant to Bobby's motive and would have resulted in the trial defense counsel being able to establish his motive for Ms. Halbach's murder and the meet and Denny standard. As Mr. Avery's sexual homicide expert, Ambergus, Ph.D., opens in an affidavit submitted previously to the court, there was a well-established causal connection between pornography consumption and violent behaviors. Affidavit Ambergus. In Mr. Avery's motion to reconsider the court's prior decision, former FBI agent and police procedure expert Greg McCary submitted an affidavit wherein he described his opinion that the searches for violent underage and child pornography combined with the images of the search of dead bodies reflects the comorbidity of the sexual paraphernalia. Yikes. There's an opinion that Ms. Clarity Bobby Dassey was becoming obsessively deviant in his viewing of violent pornography in weeks before Ms. Halbach's murder. The second prong of the Denny test, the opportunity prong, asks, could the alleged third-party perpetrator have committed the crime directly, indirectly? In other words, does the evidence create the possibility that the third party committed the crime? Bobby's opportunity to commit the murder of Teresa Halbach. As a legal concept, opportunity appears in Wisconsin context and other acts. The case law, 90402, permits the introduction of other acts, evidence to show a person's whether party to their person, opportunity to engage in certain conduct. Opportunity is a broad term. Proof of opportunity may be relevant to the place of the person, the scene, an offense, time of proximity, or to prove whether one had requisite skills, capacity, and ability to carry one out act. An incumbent on the proponent, however, to show the relevance of opportunity evidence. According to the trial court, Mr. Avery's trial defense counsel was already established that Bobby had opportunity to commit the murder of Ms. Halbach. The Sawinski evidence greatly strengthens the opportunity argument because Bobby is in possession of Ms. Halbach's vehicle where her murder likely occurred. Bobby's access to the items of evidence to frame Mr. Avery. Additionally, the defense theory was that Mr. Avery was framed by evidence being planted in Ms. Halbach's car, in Mr. Avery's trailer, and burn barrel. Sawinski evidence that Bobby was in possession of Ms. Halbach's vehicle provides opportunity to access the items that were used in the frame-up. The specific items that were planted and used to frame up Mr. Avery were Mr. Avery's blood in Ms. Halbach's vehicle, Ms. Halbach's RAV key in Mr. Avery's bedroom, and Ms. Halbach's electronic devices in Mr. Avery's burn barrel. Bobby had access to Mr. Avery's blood. Mr. Avery told law enforcement in a recorded interview that his finger, which had been cut open prior to October 31st, re-bled on November 3rd, 2005, and dripped blood in his bathroom sink and on the bathroom floor. He also bled inside. He bled on the trailer that he was removing when he reopened his cut. He then bled inside his truck. He bled inside his car. There was blood in his house, everywhere. And not a speck of DNA of Teresa Halbach's anywhere. Drip blood in his bathroom sink, bathroom floor. In Mr. Avery's trial, Roy Johnson, the owner of Mr. Avery's trailer, testified that he observed the cut on Mr. Avery's finger was present prior to October 31st. Mr. Avery consistently expressed his belief to the attorneys and the media that his blood found in Ms. Halbach's vehicle was planted, that it came from his bathroom sink. Mr. Avery's claim that he bled into his bathroom sink and on the floor was corroborated by the fact that law enforcement found some of his blood around his bathroom sink and on the bathroom floor. In early evening of November 3rd, 2005, Sergeant Andrew Colborn came to the Avery salvage yard and spoke to Mr. Avery after meeting with Sergeant Colborn. Mr. Avery went to his vehicle and drove to the Dassey residence. Barb, Blaine, and Bobby were at home at the time. Mr. Avery provided an affidavit on June 29, 2018, said the following in the affidavit regarding the events of the evening of November 3rd. I stopped by my sister Barb Dassey's Yana's house property and broke open a cut on the outside of the middle finger right hand that was attempting to unhitch her trailer for her. I went to Barb's door to see if any of her sons wanted to go to Menards. Bobby and Blaine were home. I asked Bobby and Blaine if they wanted to go with me and my brother Chuck to Menards. I told both of them that the law enforcement officer had just left the property after asking me the question about Miss Hallbach's visit to photographer Barb's van on October 31st, and noticed that Bobby was immediately nervous about after I mentioned the visit by the officer. He said he could not go with me to Menards and that he had things to do. There's no doubt in my mind that Bobby saw that my finger was bleeding. My memory in the Blaine, he wanted to go to Menards. Went to Chuck, and prior to leaving Menards, I returned to my trailer to put tape on my bleeding finger. A large amount of blood dripped onto the rim and the sink and floor of the bathroom. I did not wash away or wipe up because Chuck was waiting for me to go to Menards and Manitowoc with him. While we were leaving Avery property, traveling to flatbed in Menards and Manitowoc, I saw taillights in front of the trailer. The taillights were further apart and higher off the ground than the sedan taillights. I told my brother who was driving about taillights. We turned around and drove to the trailer. Now, in Stephen Avery's November 9th interview, he states that it could have been Bobby when he seen lights. And we have in jail calls that after they shut down Avery Road with the school buses, they would use the road between Cuss Road and Stevens property to exit and enter the property. Chuck was waiting for me to go to Menards and Manitowoc with him. While we were leaving Avery property, driving the flatbed at Menards and Manitowoc, I saw taillights in front of my trailer. The taillights were further apart and higher off the ground. We turned around and drove to the trailer. The vehicle was gone. On November 4th, I woke up at 6 a.m. and went into the bathroom to take a shower. I saw most of the blood in my sink, which I had not cleaned up in the previous night, was gone. It seemed to me that the blood had been cleaned up. After reviewing more case documents and thinking about what happened on November 3rd, 2005, I do not believe that law enforcement broke into my trailer and took blood from my sink and planted it in Miss Hallbach's vehicle. Well, let's just take into consideration on November 4th, when Link and Remaker arrive on the property, they're able to go all the way to Stevens' trailer. Don't know what they were doing because they don't find out that they're there until they run Stevens' plates. Now, who's to say that Colborn didn't go down to Stevens first and then go to the Avery office? We don't know because he didn't file a report. And he didn't file a report until 8 months after the fact, when he was instructed to when Manitowoc did their summary report. According to Mr. Avery, he left his door unlocked when he went to Menards. However, Dassey also had a key to his residence. Mr. Avery told law enforcement and trial defense counsel that he was leaving his property around 7 p.m. on November 3rd, 2005, and exiting on Highway 47 observed two taillights close to his trailer. Mr. Avery also told trial defense counsel the blood had been removed from the sink. Now, we got video evidence from him walking into Menard at 7:21. And based upon the route that means that Colburn's time to see Stephen is very short, because he gets off the phone at 5:45 talking to Jody at his mother's house, and then they leave for Menards. So you got to take into consideration him leaving, then them coming back, him going from his mom's to the Dasseys, cutting his hand, going in the house, coming out, leaving, coming back, and then going. And then after the return trip from Menards, they stop at the jail. He puts $50 on Jody's books, and he's back at home by 9:30 to talk to Jody again on his house phone. Previous calls we did not have access to. According to Mr. Avery, he left his door unlocked when he went to Menards. However, Dassey also had a key to his residence. Mr. Avery told law enforcement Child Defense Counsel he was leaving approximately at 7 p.m. Actually, on High 147, he observed taillights close to his trailer. Mr. Avery also told Child Defense Counsel that he noticed that the blood had been removed from the sink and entered his bathroom in the early morning of November 4th. Third and final prong of the Denny test was actually the evidence that alleged the third-party perpetrator actually committed the crime directly or indirectly. The Sawinski evidence demonstrates that Bobby could have committed the murder because he is in possession of Ms. Halbach's vehicle, where the murder likely occurred as evidence of Ms. Halbach's blood in the vehicle. The vehicle is a key piece of evidence in the crime. The new evidence of Ms. Halbach's vehicle was returned to the sales yard from a different location and corroborated by the fact that the witness saw a vehicle similar to Halbach's leave the property on October 31st. In Mr. Avery's trial, Mr. Quinn, propane driver, testified he saw a green mid-size SUV leaving the Avery salvage yard driving towards Highway 147 between 3:30 and 4. He informed law enforcement about this when he stopped at the roadblock a few days later and heard about the news of Ms. Halbach being missed. Further, corroborated by Bobby's brother Blaine, account on June 25, 2018. Bobby's brother Blaine provided Mr. Avery's current post-conviction counsel with an affidavit attesting on October 31st, 2005, when the school bus driver brought Brennan and me home as we traveled west on 147, I saw Bobby on 147 in a bluish or greenish vehicle heading towards Michigan. Bobby was not driving his black Blazer. Bobby was not home to the rest of the day when I was home. Bobby's trial testimony contradicts Blaine's affidavit because Bobby testified that he was home at 5 p.m. Bobby was with Michael Osmundson when Ms. Halbach's vehicle was discovered on November 5th. Current post-conviction counsel investigator met with the interviewed Osmundson about whether he was the individual with Bobby pushing the RAV4 on the Avery salvage yard. The interview was conducted because Osmundson fit the height, weight, and beard description provided by Mr. Sawinski, an individual helping Bobby push the car. When Osmundson was asked if he was an individual who helped Bobby push the vehicle on the Avery property on November 5th, 2005, Osmundson responded that he could not remember if he was that individual. This the shit I don't understand. Now, if you ask me, did I ever help somebody push a vehicle on a specific road? No, I haven't. Never in my life. I wouldn't say I don't remember. I can't remember. I don't recall. It's so stupid. Further evidence of Bobby's dishonesty. Bobby never reported to law enforcement the alleged statement Mr. Avery said to Bobby and Osmundson about whether they wanted to help him get rid of a body. This was a major issue at trial. Trial defense counsel moved for a mistrial, pointing out that they had never been appraised of the Bobby's new claim. During Bobby's direct examination, Prosecutor Kratz asked Bobby, "Now, Bobby, on the 3rd of November, that would be a Thursday, I believe, do you recall having a conversation with Uncle Stephen regarding the body?" Now, that phone call couldn't have happened on the day they said it has, or this talking about a body, because he states that they were hanging up the deer when it happened, which was on the 4th, Friday, not Thursday. And Mike O claims to have never been on the property. So Bobby testified that Mr. Avery stated his remark about getting rid of a body in jest on November 3rd when he and Mike Osmond were in his garage. However, Osmond told law enforcement Mr. Avery made such a statement to them on Thursday, November 10th. The only time Osmond was on the Dassey residence between October 31st and November 11th when Bobby was inside the Dassey garage. Mr. Avery came over. This claim is equally false since Mr. Avery was arrested on November 9th, 2005. Exactly. Why did Don Dietering and Detective Jacobs and Mark Wieger and Tom Fassbender all completely ignore that? Remarkably, Osmond stated to law enforcement that the first learned about the missing girl on Tuesday, November 1st. Another red flag. How is he hearing about the missing girl on November 1st when she's not reported missing until November 3rd? Further, the record reveals that Osmondson and Bobby were either successfully calling each other repeatedly or with each other at relevant times after Miss Halbach's murder. Bobby's phone records reflect on October 31st, 2005, there were 7 phone calls between Bobby and Osmondson occurring between the following times in the morning: 6:12, 6:36, 3:56, 3:57, 4:53, 5:10, and 6:01. Bobby's phone records reveal that Bobby called Osmondson a total of 66 times between October 24th and November 9th. Sawinski evidence is newly discovered and directly linked Bobby to Miss Halbach's murder because of previously stated Miss Halbach's RAV4 was a key piece of the evidence in her murder. Sawinski evidence provides for the first time the missing direct connection between Bobby and third-party suspect in Halbach's murder, therefore cumulative. Reasonable doubt Mr. Avery's guilt. If the defendant satisfies all 4 criteria in the discovered evidence, the ruling court that examines whether it was responsibility probably that and a jury heard the newly discovered evidence, it would have reasonable doubt as the defendant's guilt. Remember, the jury asked to review Bobby Nash's testimony, and the judge denied it. Overall evidence against the defendant may not serve as a basis for excluding evidence of third-party opportunity. No logical conclusion can be reached regarding the strength of continuity. Bobby established a viable third-party identity suspect. The forensic evidence in the case is completely undermined. Newly discovered evidence that Bobby was in the possession of Ms. Halbach's vehicle means that he had opportunity to access to plant evidence in the vehicle from the vehicle. Because Bobby has been directly linked to the murder of Ms. Halbach, there is reasonable inference that he planted the bones in Mr. Avery's burn pit. This new evidence creates a reasonable probability that, had the jury heard that the new evidence would have been reasonable doubt of the defendant's guilt, therefore Mr. Avery would grant a new trial. Brady violation of Sawinski's evidence. Sawinski evidence not only newly discovered evidence, but it also meets the criteria of Brady violation. After Mr. Sawinski contacted Mr. Avery's current post-conviction counsel and provided newly discovered evidence, Mr. Avery's current post-conviction counsel, through its investigator, submitted a second public records request pursuant to the Freedom of Information Act for audio recordings of incoming and outgoing phone calls and/or radio dispatches between November 3rd and November 9th as related to the Halbach case. Mr. Kirby attached an incorporated hearing Exhibit C. The FOIA produced audio recordings did not contain Sawinski's call on November 6, 10:28 p.m., nor did they contain any dates or times or calls produced. Well, we initially didn't get shit for audio. There's like 36 calls on one and then 40-something on the other, and then the rest is all just dispatch. Not time-stamped whatsoever. In May of 2022, Avery's current post-conviction counsel received a previously suppressed Sawinski call in Manitowoc Sheriff's Office, which contained a partial recording of a suppressed call to the Manitowoc Sheriff's Office on November 6, 2005 for the first time. I hope Zellner realizes that there's 3 dispatch lines, and we only have audio for 2 of them. 4201 and 4202. We don't have the 4200. The 4200 number was posted in the paper, so everybody in the public that got that paper saw it. So why don't we have a single audio file from it whatsoever? May 2020, November 6th, for the first time, current post-conviction counsel received exact dates and times of the Manitowoc County Sheriff's Office incoming calls. Attached to the incorporated hearing, Exhibit D, is a track stamp record from the disclosed provided in May of 2022. As a part of his further investigation, Mr. Avery's investigation interviewed Mr. Sawinski's ex-girlfriend, who he has dated at the time of November 5th incident with Lewinsky's ex-girlfriend. Novak corroborated Mr. Lewinsky's account of what he had witnessed, and they had relayed to law enforcement further. Mr. Novak recognized and identified Mr. Lewinsky's voice on the recording placed to her by the investigator on a phone call made to Manitowoc Sheriff's Office on November 6, 2005 at 10:28 p.m. Mr. Avery Novak attached is incorporated here as Exhibit E. Mr. Avery, investigator, also interviewed Mr. Lewinsky again and played the same audio recording of the phone call that was made to Manitowoc Sheriff's Office on November 6. Mr. Lewinsky identified his voice in the audio recording in the phone call from November 6, 2005. The recording of Mr. Lewinsky's call was never disclosed by the state to Mr. Avery's trial defense counsel. Prior to or during the trial, trial defense counsel made two specific requests pursuant to 97123 for all exculpatory evidence and or information within the possession, knowledge, and control of the state, which would be tend to negate the guilt of the defendant, which could tend to affect the weight or credibility of the evidence used against the defendant, including inconsistent statements. The second request was made by trial defense counsel for Brady material immediately before trial on January 18, 2007. Mr. Avery's trial defense counsel, Mr. Dean Strang, and Mr. Jerome Beauty are attached to incorporate here Group E, G, including the attached exhibit trial defense counsel's July 24, 2006 letter to Prosecutor Kratz requesting all audio tapes in the Brady Supreme Court held the prosecution violation accused, the constitutional yada 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 yada. It can be produced violations for good faith, bad faith, prosecution. Established Brady violation, the defendant must demonstrate that the prosecution suppressed evidence. The state never discloses Lewinsky evidence or the Lewinsky call to Mr. Avery's current or past counsel. The defense never received a law enforcement report. Lewinsky evidence provided in the Manitowoc Sheriff's Office in November 2005. Lewinsky evidence is corroborated by a partial recording of his attempt to report the evidence to the Manitowoc Sheriff's Office prior to his calling being transferred. There is no recording of law enforcement report in the remainder of Mr. Lewinsky's call that Mr. Avery, current post-conviction counsel, through reasonable diligence, has been able to locate through his public records request. How about you guys go take a look inside the safe? I'm sure anything they have, like the missing voicemail that Dennis Jacobs took. Further, the Wisconsin Supreme Court has specifically rejected the imposition of reasonable diligence standard on trial defense counsel. The Wisconsin Supreme Court specifically stated the court never analyzed Brady claims through the lens of this rule. Blah 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 blah. There's no express in the United States Supreme Court. There's no duty for defense. It's a lot to read. I'm only 31 pages in, and there's still 270 more with the other two documents. But this is just like her going over everything in time, and yeah. December 26, 1042, Michigan emails related to lawyers. Reserved on November 5th. Subline email, we need to talk. Mr. Avery's current post-conviction counsel conducted an investigation. Mr. Lewinsky included gathering information about the following date. Current post-conviction time, relative time period. Mr. Avery's current post-conviction counsel attacked Mr. Avery's child defense, Mr. Beauty, who confirmed that Mr. Avery's child counsel had not received emails from Mr. Lewinsky. Mr. Avery's current post-conviction counsel reviewed all discovery FOIA requests made by the prior counsel, current post-conviction counsel of the Manitowoc Sheriff's Office, and information related to Lewinsky's evidence encompassed with the requests and produced or not. April 7th, Mr. Avery's current post-conviction counsel sent a letter to Mr. Lewinsky, local investigator in Denver, Colorado. Mr. Avery's post-conviction counsel determined that Mr. Lewinsky resided. Requested Mr. Lewinsky contact Mr. Avery's current post-conviction counsel office immediately. April 8th, Mr. Avery's current post-conviction counsel clerk said telephone contact Mr. Lewinsky. April 9th, Mr. Avery's current post-conviction counsel contacted a phone interview. Then they prepared an affidavit on his statements in the interview. Mr. Lewinsky, because he was going to be visiting family in Manitowoc on April 10th. Post-conviction counsel investigator Stephen Kirby met with Mr. Sawinski in person at Manitowoc for an interview and reviewed his affidavit with him. After trial and evidence, Mr. Sawinski reported that Manitowoc's officer had observed on the Ivory property delivering newspapers on November 5th. Actions towards afterwards, as affidavit including the map indicating where he observed two males pushing around 4. After reviewing the affidavit and making necessary changes, Mr. Sawinski executed the affidavit for a Wisconsin notary. April 12th, Mr. Avery's current post-conviction filed a defendant appellant's motion establishing Brady violation, third-party Denny suspect. Avery's current August 28th, counsel listened to all audio recordings and the possession from discovery as well as his own investigation determined there was no recording matching the description Mr. Winston provided to the Manitowoc Sheriff's Office. Mr. Avery's current post-conviction counsel through an investigation submitted following 3 new public requests for the Manitowoc County Sheriff's Office. First request, copies of all 911 recordings in your counsel possession, incoming telephone calls from Manitowoc Sheriff's Dispatch Center between the dates of November 3rd and November 9th. I think they should have went all the way to the 12th, in my opinion, but my opinion means nothing. The second request through copies of community telephone call logs recorded Manitowoc Sheriff's joint dispatch calls between dates of November 3rd, November 9th. The third request is copies of recording calls dispatches between the dates of November 3rd and November 9th. On May 3rd, a response to Mr. Avery's current post-conviction counsel on March 15th, 22 public requests for an investigator. For the first time, recordings were provided to Mr. Avery's current post-conviction counsel, who thoroughly reviewed and listened to all the audio recordings and located one of the interests, which took place on November 6, 2005, 10:28, first time and the time and date that were called revealed on the track files. For the first time, the time and date of the calls were revealed on the track files. Now you see that date. Requested these same things and was given what we've always got before. Or was told, sorry, we don't have those anymore. They've been destroyed. Yeah, okay. On August 6th, Kirby met with Ms. Sawinski's former girlfriend and played her the audio recording. Ms. Novak identified the voice call as Mr. Sawinski. Ms. Novak provided Mr. Avery's current post-conviction counsel with affidavit. August 6, 2022, current post-conviction counsel Kirby met with Mr. Sawinski and played him the audio recording from November 6th. And Mr. Sawinski identified the voice on the call as himself. As stated above, after a very thorough investigation of Mr. Sawinski's individually and current accuracy of information he provided as Sawinski evidence, Mr. Avery's current post-conviction counsel determined that Sawinski evidence necessitates filing a third 97406 motion in order for the defendant to prevail on the third component of the Brady analysis. Suppressed evidence must be material, and this was definitely suppressed for 17 years. Okay, question, another one. Mr. Avery's conviction for first-degree intentional homicide was in large part based on trial defense counsel's unsuccessful efforts to name a third party Denny suspect that met all of Denny requirements. Sawinski evidence meets the Denny requirements, makes Bobby a third-party Denny suspect. Opportunity to plant the blood, DNA, plant the key, vehicle, bedroom, burn barrel. Sawinski new material evidence was suppressed when the Manitowoc Sheriff's Office failed to disclose on November 6, 2005, 10:28. All recordings pursuant to the defense discovery request. Disclosure of the audio recording would have led to identification of Sawinski and the evidence provided with directly connects Bobby to the murder and the framing of Mr. Avery. Sawinski evidence and material because it makes Bobby a third-party suspect in the murder as well as a source of planted evidence used to convict Mr. Avery. Sawinski evidence also impeaches Bobby's testimony and refutes the state's theory that Hallbach RAV4 ever left the Avery property and that Mr. Avery was the last person to see Mr. Hallbach alive Further, materially favorably evidence not only includes exculpatory evidence, also evidence impeaching and prosecution witness, evidence tending to demonstrate the lack of credibility to prosecution within the material, especially where a prosecutor's case depends on the credibility of the witness. Bobby was the state's primary witness against Mr. Avery at trial. During his opening statement, Prosecutor Kratz explicitly informed the jury that as significant as Bobby put to an observation on the date of Ms. Hallbach's disappearance, you are going to hear that Bobby Dassey was the last person, the last citizen that will have seen Teresa Hallbach alive. Bobby testified that he observed Ms. Hallbach's vehicle pull up in the driveway at 2:30 p.m., October 31st, 2005. This is just going over everything we already know. I'm just going to skim over this. I'm going to put the links to these in the description of the video so you guys can actually go over there and read this yourself. Otherwise, you can find them on Reddit, numerous Facebook pages. On November 4, 2005, I returned my mother's trailer, retrieved some clothes. I had a conversation with my brother Bobby about Teresa Hallbach. I distinctly remember Bobby telling me Stephen could not have killed her because I saw her leave the property on October 31st. Please, what date? What are you referring to, Travis? Appellate court highlighted the importance of Whiskey's evidence within the state of the following July 28, 2021 opinion. To admit evidence at trial that Dassey could have killed Teresa Hallbach, Avery would have had provided some evidence at the pretrial day hearing directly connecting Dassey to the crime and committed to the admissible pursuant to any of the third party. Remember that date? July 28th? Or November 4th. You got me confused, Travis. Oh, the first time. Oh, yeah. Definitely. We know the first time he was suppressed was back in 2005 or 2006. The importance of Whiskey's evidence from the fund, admitted evidence Dassey would have killed Hallbach. Okay, opinions. But appellate court determined there was sufficient evidence to meet the Denny requirements to admit evidence at trial that Bobby could have killed Ms. Hallbach. It is also advised that Swinsky evidence could be that missing direct connection. Because the Swinsky evidence was suppressed, the trial defense counsel was not able to establish Bobby as a third-party Denny suspect or impeach Bobby's trial testimony as the state's primary witness. As a result, Mr. Avery did not receive a fair trial. Mr. Avery had a constitutionally guaranteed right to present complete defense to the charges against him. Yeah, for the first time. And you gotta remember, Travis, if it wasn't for Remaker referencing, listening to audio to prepare for his testimony, they wouldn't even have known about it at all. And Buting requested the audio that he used to prepare for his testimony. He should have requested all audio. But again, Lloyd requested the audio back in the beginning when his first attorney, and they told him we don't have that stuff. So from day one, they were suppressing things. And we all know why. They wanted to make that lawsuit go away, which they did. reasonable probability of different result. Mr. Avery is not procedurally barred from raising his Brady claim. A motion for relief 9706 is part of the original criminal act and may be made at any time. However, a defendant must meet certain requirements. All grounds for relief available to the person under the section must be raised in his or her original supplemental amended motion. Any ground finally judging educated or not so raised or knowingly, voluntarily, intentionally waived by the proceeding results in the conviction and sentence. The other proceeding person is taking secure relief was asserted with sufficient reason, was not asserted in any way raised in the original supplement amended motion. The state, the Wisconsin Bureau claimed it had been raised or appeal the previous. Keeps citing the same cases. Mr. Avery filed Smith's motion to stay the appeal, remand, evaluation, new claim. Appellate court determined that the circuit court should resolve standalone basis. And this is here we are now. The circuit court, or the appellate court, advised Sellner to resubmit what we're going over right now back to the circuit court. And before Judge Suck at This could make a response to what Zellner is asking, the Attorney General for the state of Wisconsin intervened, asking her to deny her motion, asking for an evidentiary hearing. Because the Attorney General is involved, all the way up, from Peg all the way down. They whitewashed his first case. The Squincy evidence provided by the Sheriff's Office number 6 was unknown to Mr. Avery's, undiscoverable at the time. Mr. Avery's 2017 post-conviction motion, 2013 post-conviction motion, direct appeal, and 2007 trial. It could not be known, discovered. It still bothers me that there's 3 dispatch lines and we only have audio for 2 of them. And the one that was put in the paper is the one we don't have audio for. Even if the court determines that the Brady violations, once the evidence qualifies as newly discovered evidence as described above, Mr. Avery has sufficient reason for not having brought forth newly discovered evidence. How can he bring forward something he had no knowledge of? I don't know. The second violation, Hall Box Rap 4. And now we got Kevin Ramlow. And remember, Robert Fabian also claims to have seen a vehicle parked at the same location as Ramlow, but when the investigators talk to him, it now changes. It's now a Jeep. Kevin Ramlow came forth from Mr. Avery's current post-conviction counsel with new information on July 17th. And the fact that Kevin Ramlow reached out to Scott Tadash first, and he just brushed it off. Kevin Ramlow, the 17, provided an affidavit, supplemental affidavit to current post-conviction counsel because Mr. Avery's second post-conviction motion was filed on June 2017. These affidavits were filed in Mr. Avery's motion to reconsider the Circuit Court's October 2017 ruling denying his second post-conviction motion. In Mr. Ramlow's affidavit, Mr. Ramlow described observing Ms. Hallbach's RAV4 parked at the turnaround on State Highway 147 and the East Twin River Bridge on November 3rd and November 4th. Mr. Ramlow describes in his affidavit reporting to his opposition the Manitowoc Sheriff's deputy encountered on November 4th at the Senex station on State Highway 147 in Michigan. No law enforcement report was ever generated by the Manitowoc Sheriff's deputy memorializing this conversation between Ramlow and his deputy. Mr. Ramlow's observation is Hallbach RAV4 on November 3rd and 4th, 2005 is material to trial defense counsel's theory that evidence was planted to frame Mr. Avery. If the RAV4 was spotted at the turnaround on Highway 147 on November 3rd and 4th, then it must have been moved and planted on the Avery property before it was discovered on November 5th. Clearly, This information supports trial defense counsel's theory that the RAV4 was planted on the Avery salvage yard before it was discovered on November 5th. Around those observations, that's why we have the flyover is edited 1,000%. Clearly, information supports trial defense counsel theory that RAV4 was planted on the Avery salvage yard, discovered on November 5th. Around those observations, November 3rd and 4th, of a haulback vehicle turnaround on Highway 147 corroborated Mr. Sawinski's observation in RAV4 being pushed down a road which directly intersects with State Highway 147 in the early morning hours of November 5th, 2005. Both witnesses support trial defense counsel theory that the RAV4 was planted. Prosecutor Kratz admitted in his closing the RAV4 couldn't have been driven onto the property unless somebody knew that property. The other evidence presented to the state RAV4 left the Avery property after October 31st, 2005 was Bobby's testimony that the RAV4 was still present when he left the Avery property at 2:45. Trial defense counsel had no evidence from the witnesses that the RAV4 was planted and simply argued in the closing that there were lots of ways to get in and for someone to plant the vehicle. Mr. Avery is now procedurally barred from raising his Brady claim. In the appellate court's July 2020 opinion, the appellate court noted that in Mr. Avery's motion for reconsideration, he raised the issue that the state withheld evidence that the haulback vehicle was seen on the streets days after his disappearance. The appellate court declined ruling on this issue, but advised the following. Neither we nor the circuit court have severely considered whether these claims are procedurally barred under Escalon and Annual, or whether they have pled sufficient material facts entitling him to a hearing. Such consideration would have come to a separately filed Wisconsin 97406 motion, and we express no opinion as to whether such claims would be barred in the event that the motion is filed. Clearly, current post-conviction counsel could not include Mr. Ramlo's affidavits in June 2017 on behalf of the Mr. Avery's, since Mr. Ramlo had not yet come forward with evidence that established the Brady violation. There is no way Mr. Ramlo could have been discovered prior to defense counsel or current post-conviction counsel because no law enforcement reports were prepared about his conversation with the Manitowoc Sheriff's deputy, nor did he appear in any other law enforcement reports in the Hallbach murder investigation. He had never been a customer at the Avery salvage yard and had no connection with the family besides being acquainted with Mr. Tatt's brother. Mr. Avery was unable to discover the Brady violation reasonable diligence prior to the filing of his second post-conviction motion in June 2017 because Mr. Ramlo did not come forward to Mr. Avery's counsel until after June of 2017. He came forward in July of 2017, which is impossible for Mr. Avery to raise the Brady claim without Mr. Ramlo first coming forward to current post-conviction counsel. Therefore, Mr. Avery has sufficient reason for not raising the issue previously pursuant to Escalon now. In the alternative, Mr. Avery entitled to a new trial in the interest of justice pursuant to Wisconsin 80515. Alternatively, Mr. Avery entitled a new trial to the interest of justice. If the court were to conclude that the new evidence warrants a new trial in the interest of justice, the court need to resolve whether the new evidence was satisfied as in the test for granting a new trial. Based upon newly discovered evidence, established that the standard granting a new trial under circumstances such as these is whether the new trial could have advanced the interest of justice, and party may move to set aside the verdict to the new trial because of the errors in the trial, or because the verdict is contrary to the law of weight of evidence, or because excessive and inadequate damages, or because newly discovered evidence, or the interest of justice. Courts may grant new trial in the interest of justice whether either the real controversy was not fully tried, or two, it is probable that justice was for any reason miscarried. In the first circumstance, when the real controversy has not been fully tried, the court may grant a new trial without considering whether the outcome would probably be different on retrial. The Wisconsin Supreme Court has established that new evidence can provide the basis for a new trial in the interest of justice. The court ordered a new trial in interest of justice because new DNA tests established biological evidence asserted by the state at trial has come from Armstrong could not have come from him. Because the jury was not given the opportunity to hear important testimony that the bore and the important issue in the case, the court found that the real controversy was fully tried and that thus ordered a new trial. This is just case sites. An evidentiary hearing is requested. The circuit court must hold a hearing when the defendant has made a legally sufficient post-conviction motion and has discretion to grant or deny evidentiary hearing, even when the post-conviction motion is legally insufficient. The Wisconsin Supreme Court in State v. Allen determined that the motion contains sufficient materials, facts, and evidentiary hearing if it includes the names of the witnesses, who, the reason the witness is important, why, how, and the facts that can be proven, which were when, and would entitle the defendant to a hearing. If Mr. Avery was sufficiently pled the name of the witness, Mr. Sawinski, and the reason Mr. Sawinski is important, he provides evidence material and favorable to Mr. Avery by directly connecting Bobby to the Hallbach murder as a third-party suspect and connecting Bobby to planting evidence to frame Mr. Avery. All corroborating materials have been identified, attached, and incorporated in this motion, affidavits, law enforcement reports, trial testimony. These corroborating materials demonstrate that Bobby is a third-party Denny suspect because he had motive, opportunity, and directly linked Miss Hallbach's murder. Additionally, he is a Denny suspect who is directly linked to planting evidence to frame Mr. Avery by having access to the key evidence of the crime because of his possession of the Hallbach vehicle. Additionally, a new Brady violation has been identified and described previous and in the motion. Similarly, Mr. Avery has sufficiently pled the name of the witness, Mr. Ramlow, and the reason Ramlow is important. He provided evidence material and favorable to Mr. Avery, refutes the state's theory, impeaches Bobby, the Hallbach vehicle never left the Avery property. Also, Mr. Ramlow describes a new Brady violation. A law enforcement report was never made of Mr. Ramlow's conversation with the Manitowoc Sheriff's Deputy on November 4th, 2005, and Ramlow spied in the RAV4 in the location away from the Avery property. If a child defense counsel has information that have been able to refute the theory that impeach Bobby. So Winsky and Ramlow evidence would have been favorable, determined blah 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 blah. The courts can decline the Wisconsin eliminate evidence. The court must hold a hearing before making credibility determinations, holding credibility issues the best conclusion. Mr. Avery respectfully requests that the court grant him one of the following alternative remedies: grant the evidentiary hearing, grant this amended motion for post-conviction. All right. Exhibits A1 and A2. DCI report. Interviewed Brad Dassey. So we got Brad Dassey's DCI report. I'm not going to read all this because I've already read all of them, and all this stuff is available online. How about control the evidence, control of that? This is the no. So this is Brad's email to the Hallbox. A DCI report. Brendan and Stephen are persons of interest. Fabian, Barb, Emily, Marie. I find it funny that they sometimes it says Marie, sometimes it says their other name. I mean Avery, not Marie. February 21st, Fastbender, Richard Weger, Kelly McConey, Department she's a personal computer, CPU, 12 CDRs. And this is all the reports generated from DCI and Calumet County. Exhibit B, affidavit of Stephen Kirby. On February 16, 2022, your friend interviewed Michael Osmondson outside of his residence on Main Street. Jim Kirby was also present and witnessed the interview. Osmondson's responses. Your client asked him if he ever helped Bobby Dassey push a cart on a road leading to the Avery salvage yard. He replied, I don't recall. Your client then asked him if by saying he didn't recall, in fact, he could have helped Dassey push a car down the road in November of 2005, but just forget it if he did. He replied, I don't remember. At the conclusion of the interview, your client told him that your client wanted to be sure that he was not denying ever pushing the car with Dassey towards Avery property, but that he just couldn't recall if he did or did not. For the third time, he replied, I don't recall. In regard to the phone calls on October 31st, 2005, from Bobby Dassey's phone number, he said he didn't recall making or receiving calls from Bobby Dassey that morning. When he was shown the printout of the message units, it said 920-773-1514 was his number. His number recognized that 920-973-1742 was Bobby's number. He said that an early morning call could have been about hunting, but he didn't know for sure. When he asked if he was hunting with Bobby that day, he said he didn't. He took his brother trick-or-treating. You took your brother trick-or-treating the whole day? Because first you had to pick him up from school. But when I asked him what time to with Bobby, he said didn't his brother trick-or-treating. When he asked about the multiple calls from Bobby Dassey between 3:56 and 6:02, he said he couldn't explain them other than Bobby often doesn't answer his own phone. Now, why doesn't Bobby Dassey want to talk to the Kirbys? Why doesn't Scott Taddick want to talk to the Kirbys? Why is everybody else talking to the Kirbys but those two? Those two that alibied each other, I might point out. Their fine legal majority truly, completely justify the matters concerning based on blah, 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 blah. On March 20th, public record request to Manitowoc Sheriff seeking all 911 recordings and possession of incoming calls. Dispatch Center from November 3rd and November 5th. Your fine subsequently received package in the mail from the Manitowoc County Sheriff's Office, which included 2 CDs. A letter dated April 12, 2008, addressed to me, signed by Larry Lavina, Deputy Inspector in Manitowoc County Sheriff's Office, stating, we have received and reviewed your request from non-911 recordings in our possession of incoming calls to Manitowoc County Joint Dispatch Center from November 3rd, 2005 and November 5th, 2005. The dates in question are outside of our recording system storage. Blatant lie. But in the time frame we requested recording, the copies we made time frame due to different record requests were therefore they supplied her with 2 CDs. And again, we don't have the 683-4200 number that was put in the paper. Everybody that got the Milwaukee Journal-Sentinel in Wisconsin, which is disputed throughout the whole state, that was following this case would have seen the 4200 number in the report in the paper. So why don't we have a single fucking call from that number that was put out to the public? But again, after they resubmit and ask for this same information again, what do? Oh, now we have 35 discs with 35 calls on each one. So it's over 1,000 something discs. Like, Calumet County's dispatch is 19,038 files. And I've been through all of them multiple times. Took me a month. Manitowoc, it's 79. The first batch that they released ever was 79 calls in all. And the rest of the audio is all dispatch, which is very important if you actually listen to it. On March 15, 2022, investigator Catherine McGovern in the Finance Office submitted 3 public records requests to the Manitowoc County Sheriff's Office. The first request sought copies of 911 recordings, incoming telephone calls to the Manitowoc Sheriff's Department Dispatch Center between the dates of November 3rd and November 9th. The second request sought copies of the incoming outgoing telephone calls from the record Manitowoc County Sheriff's Joint Dispatch calls between the dates of November 3rd and November 9th.
that related to Teresa Halbach's investigation. Information should include the date, time, and telephone numbers involved in the calls. The third request sought copies of audio recordings, incoming and outgoing calls, or radio dispatches between the dates of November 3rd and November 9th. I think they should have went all the way to November 12th. And my question is, can we get calls from, say, 2/26 to the 4th of March? Be interesting to hear what's all going on while they're interviewing Brendan and running back and forth from Hickory Hills to the Avery's property prior to them getting the search warrant. On April 18th, 2022, discovered regarding requests, copies and coming outgoing calls, have reference, the copies amount to $360, records. Requested your advice off it, remit payments so that she begin working copying these records. Your finance office subsequently paid the invoice for the requested amount. On May 3rd, 35 CDs marked as containing audio recordings from Manitowoc County Sheriff's Office. On May 3rd, 2022, your client delivered 35 CDs to the office of Kathleen Zellner. According to the phone calls on November 6, 2005 to 2028, which was contained within the 35 CDs produced from the client's second public records request, was discovered by your client in the office of Kathleen T. Zellner. Your client listened to the call. Your client listened to the CDs produced to the client after the client's first public records request in Manitowoc County Sheriff's Office, March of 2018. The recordings of number 6, 2005 phone call in which Ms. Wincy's voice was identified, not an additional disc provided the client following the client's March 20th, 2008 public request. So, yeah. Well, that's 64 of the 400. And these are all the calls. This is the affidavit of Mr. Skowinski's girlfriend. We've read this before. Sorry. Transfer the phone call. I called Sheriff's Department. It says, Carla, can I help you? I don't know if I could. It's good information, bad information. What do I talk to you about this? Girl, Mr. Hilbert. Can you have you speak with the shift commander? Can you hold on a moment? Thank you, Sheriff. Unintelligible. I'm going to transfer you to the shift commander, Sergeant Senglob. You were talking with. Thank you. Okay. Call transferred. Scott, when I hang up, it's a man on the phone who thinks he saw maybe some more leads. He wants to speak with somebody on the case. Now, there's only 4 detectives for Manitowoc, and 2 of them were on vacation. So, well, 3 because Remaker had left for he was about to have a baby and stuff. So that left 2 detectives in charge during this whole 9 days that took place. Dennis Jacobs and Mr. Link. F, affidavit for the Thomas Lewinsky. Exhibit A. Yeah, this is his affidavit stating he's seen Bobby Dassey and another individual pushing a car down Avery Road. I mean, okay, Mr. Jeffrey Florcrum. Now, it's been proven that they purposely withheld evidence that would have benefited Stephen Avery, and you still think he's guilty. All this shady shit going on. If they had to open the shut case like they claim, they wouldn't have went after his alibi last. And they implicate him. And can affidavit And I've read your little thesis you wrote, and yeah, it's garbage. Like, I don't know. I'll address this in an email to you. Uh, duh, 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 duh. Hello, my name is Sawinski. Delivered newspapers. I delivered papers at a time when it's just reiteration email he sent to. Transcript of a phone call. Same thing. Group G. Affidavit to Dean Strang. To agree with reading the affidavit, Document 1122, my recollection of components of everything that addressed the affidavit with scope, personal knowledge, I agree with, you confirm the affidavit. And then we have affidavit of Jerome Beauty, CD-ROM, okay. I guess I'll read this. I see CD-ROMs purported to contain a Manitowoc County Sheriff's Department dispatch call related to the Hallback investigation, covering the period of November 3rd from November 12th, that CD-ROM was at some point turned over to Mr. Avery's successor counsel. I have recently reviewed the handwriting on the copy of the CD-ROM, which I recognize as my handwriting. I informed and believed, in part based on my own recollection, that this is the copy of the CD-ROM came from the files on Mr. Avery's case. I recognize my handwritten note on the CD-ROM, which refers to one call, the recording, untimed dispatcher from Sergeant Colborn. I have recently listened to all the recordings of the CD-ROM that I received during my reposition. All calls? There was like 40 or 79 in all. Which was turned over to him. After Remaker fucked up in trial. The news received CD-ROM that current counsel Mr. Avery has shared with us, which includes a call perpetrated by Mr. Sawinski, indicates that the caller was transferred to an investigator, Sergeant Scott Sanglob. By the interference, Sanglob spoke to the caller, as the recording shows that the dispatcher connected the caller to him. Neither I nor Mr. Avery's defense team ever was given a recording, a report, notes, or any other notice of the conversation between Tom Sawinski and Sergeant Sanglob of the Manitowoc County Sheriff's Department. At this time, we are requesting discovery, disclosure, explanatory information. Mr. Strang and I were using private investigator Conrad Bates. We would have him follow up on the call from Mr. Sawinski had we known about it. And Mr. Strang and I know before Mr. Avery's trial about the information that are reported to and pushing SUV property, darkness before the reported discovery of Ms. Hallback's Toyota RAV4 SUV on the Avery Salvage Yard property could have been pursued and information diligently. Mr. Bates otherwise. Had Strang and I received knowing Mr. Avery's trial about the Sawinski telephone call, the dispatcher would have also that she transferred the call to Sanglob. We'd have made specific requests for information that stands to call from Sanglob. But he didn't even file a report, so this is filed yesterday, the 24th, Travis. As of all, Colborn described paragraph 3, neither the prosecution, Manitowoc County Superior Agency, Wisconsin is closed. Recording Andrew Colborn has no timestamp or other documentation of the time of the call, which is covered. The defense of Mr. Avery, we thus had no way to challenge this to prove any of the claims Mr. Colborn might have about a specific time. My question is, if they talk to Stephen Avery just after 6 o'clock, it got to be no later than 6:30. No earlier than 5:45 on November 3rd. That gives them a very slim window to see Stephen, because they're walking in the door of Menards at 7:21, and you got to drive there. It's about a half-hour drive, and then Stephen's got to leave his mom's, go down to Barb's, move the trailer, talk to them, go in the house, leave, come back, leave again. But we got a facsimile transmission only. Special prosecutor Kenneth Kratz. I'm writing to follow up on some discovery issues in the matter. There are a number of 2 items we do not have yet, and I have gone through discovery already provided. I've tried to make note of them, but most refer to discovery and independent of that. By copy of the letter, I'm also notifying investigator of the convenience, as I assume he will assist you in responding to your requests, as well as to Norm Gahn, since some of the requests concern crime lab DNA testing. Please locate and produce the following: audio tape copies of dispatch or all other communications relevant to the law enforcement operations involved in the search for the investigation of Teresa Halbach's disappearance provided. See, this is the problem I have. We got photos from Calumet. What page are we on? We got photos from Calumet where they go into Manitowoc's evidence storage and they take pictures of Manitowoc's evidence. So, what else does Manitowoc have in their evidence locker? I'm gone, Tom Fallon. Alright, so that was the Exhibit A, Part 1. Here's Part 2. 145 pages. How long have I been doing this for? Almost 2 hours. Alright. I'm going to continue this Part 2 in a different video because I need to get to sleep because I got to be up at 6 in the morning. But, see y'all next time, and we'll continue this tomorrow. Before I go, though, y'all got any questions? We all hate the cops, Barb. A lot of touch on the cops, but what your husband and your son need to do, Barb, if you're still in here, is talk to Kathleen Zellner. If they really had nothing to do with the disappearance of Teresa Halbach. I mean, you guys talked to the cops again in 2017, but won't talk to Zellner, and then you got Bobby asking for protection from the cops. But I've been good. Took a while off, but I'm still researching every day, connecting dots. But I appreciate your persistence. I believe there are many, maybe other events that happened between November 3rd and November 5th that you're not aware of and were withheld by law enforcement. Yeah, okay. Well, we don't have audio for the 4th. They're still hiding things, but I'm going to bed. Y'all have a good night. See you next time.